Good afternoon, ladies and gentlemen, and thank you for joining us. As you are aware, every Thursday between 4 p.m. and 5 p.m., the South African Bar Association hosts a speaker to deal with a legal topic intended to assist young practitioners with training and development, which feeds into the core values that we hold as an organization. Today's speaker is no stranger to us, and we are grateful to have Advocate Maud Letzler to conduct her welcoming and conclusion. In terms of housekeeping, during the address, all participants shall ensure that they are muted. Should any participant have a question, kindly raise your hand, whereby you shall be unmuted during the question and answer session to pose your question directly to the judge. With much further ado, I now hand over to Advocate Maud to conduct the welcoming of today's speaker. Over to you, Advocate Maud.
Thanks, Ame. Judge Ingrid Opperman completed the qualifications of B Commerce and B Law at Wits University, whereafter she did a stint as a prosecutor, and in 1990 joined the bar. Now, for those of you who didn't know, Judge Opperman and her husband Les Morrison SC met during pupillage, but I think they did get some work done, as well as they wouldn't be where they are today if they didn't. Then in 2014, Judge Opperman took silk, and in 2017, not much later, became a full-time judge of the High Court of South Africa. I was thinking of a war story that I could tell in the time that Judge Opperman and I worked together as members of the Measles group, me as a baby junior and herself at that time as a senior junior. And I remember the one matter in which I was counsel on brief for Bowman Gilfillan, and Judge Opperman at the time as counsel was the curator at Littem in this matter. And the patient had a 32 million rand estate. The children indicated that they are not interested in the money, and that the curator must appoint a curator bonus and do with the money as they see fit. It was at this point in time that I decided that I think Judge Opperman and I should be adopted, and that the law definitely should change, because I thought we made excellent candidates for adoption. Other than that, those of you that have appeared in front of Judge Opperman would know, besides for her infectious laugh that lights up the boring halls of chambers behind courts, and her very inquisitive eyes, that she is one of the best judges we have. Over to you, Judge Opperman.
Thank you for those kind words, Maud. Thank you, Ahmed, members of the South African Bar Association, members of the Johannesburg Society of Advocates, the BASA, the Gauteng Attorneys Association, all those present. I'm sure nothing turns on it, but I studied at the University of Johannesburg, not Wits. I wish it were the other way around, but I should put the record straight. Now, it is a very courageous thing to start a new bar association, but you appear to have taken it on with gusto. Thank you so much for inviting me to participate in your training initiatives. I'm particularly pleased to learn that the South African Bar Association has as its core objective the ongoing training and development of junior advocates and the advancement of the female practitioners' cause. Straight to our topic then. I have 35 minutes to address you on, and have decided to focus on practical tips to help you navigate your way in the urgent court. You need to appreciate that Johannesburg and Pretoria are the busiest divisions in the country. In Johannesburg, we have between 50 and 60 matters weekly on the urgent roll, and this workload is shared between two judges. Before you start drafting an urgent application, or before you appear in the urgent court, it would be a good idea to refresh your memory on the basics. Do a quick Urgency 101 refresher. Read Rule 612 again, Chapter 9.23 of the practice manual if in Johannesburg, and the latest practice directive, which again in Johannesburg currently would be paragraphs 172 to 183 of the revised 18 September 2020 Consolidated Directive, effective from 11 June 2021. It will also be helpful to read Judge Weppener's judgment in Re several matters on the urgent role, which contains a useful summary of the most common stumbling blocks faced by litigants in this court. Now, remember that you're required to set out explicitly the circumstances which render the matter urgent. Most importantly, Rule 612B requires that the applicant must, in her founding affidavit, set out explicitly not only the circumstances on which she relies to render the matter urgent, but also the reason why she claims that she cannot be afforded substantial relief at a hearing in due course. Now, you will be reminded of what Acting Judge Noche said in East Rock Trading at paragraph 7. He said, "It is important to note that the rules require absence of substantial redress. This is not equivalent to the irreparable harm that is required before the granting of interim relief. It is something less. He may still obtain redress in an application in due course, but it may not be substantial. Whether an applicant will not be able to obtain substantial redress in an application in due course will be determined by the facts of each case. An applicant must make out his cases in that regard." As the test is relief in the ordinary course, you have to establish what is meant by the ordinary course. Is it a year away? Is it 6 months away? When you can be heard in the ordinary course. Now, I was in urgent court last week and read several founding affidavits which stated that matters in the ordinary course were heard in November of this year. This statement was factually inaccurate. What I did at the beginning of last week's urgent week was to request my secretary to establish when the registrar is enrolling matters for hearing in the ordinary opposed motion court. Last week, it was every week in August and the first week of September 2021. Now, this information makes a big difference to your argument relating to substantial redress, as the question is, why do you need your order on 22 June 2021, and why can it not wait until August 2021? In Mogalakwena local municipality versus Provincial Executive Council Limpopo and others, Judge Tuchten succinctly summarized the correct approach to dealing with urgent matters as follows. It seems to me that when urgency is an issue, the primary investigation should be to determine whether the applicant will be afforded substantial redress at a hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. Once such prejudice is established, other factors come into consideration. These factors include, but are not limited to, whether the respondents can adequately present their case in the time available between notice of the application to them and the actual hearing, other prejudice to the respondents, and the administration of justice, the strength of the case made by the applicant, and any delay by the applicant in asserting its rights. This last factor is often called, and usually by counsel acting for respondents, self-created urgency. What you should also look out for are directives published by the judge dealing with your matter. I publish such directives together with my role. In it, I provide my secretary's email particulars and request that practice notes and/or heads of argument be mailed to her by no later than 4 p.m., that's 4 o'clock on the afternoon of the Monday of the particular urgent week. But compliance with this request is actually already too late. Let me explain why. The urgent roll closes at 12 on the Thursday preceding the urgent Tuesday. I get my files during the afternoon of the Thursday, sometimes only on the Friday. I instruct my secretary to freeze the files, which means that legal practitioners are not permitted to upload any further papers without my permission. Please note that every judge has their own way of managing their court, and this address deals with my way of managing my urgent court, but I'm sure might have application and will curry favor with other judges. The only files I have are those electronic ones which appear on case lines. Judges don't get hard copy files at all for urgent applications in Johannesburg. So the first thing you should do as counsel is to go onto case lines and to ensure that a complete set of papers has been uploaded. By ensuring, I mean page through each page, and ensure every document, every affidavit is complete and legible. I often have batches of papers missing from affidavits, or some pages are upside down. Check very carefully, and if the file is not in order, fix it by mailing the judge's secretary and by requesting her to unfreeze the file to enable you to correct that file. Now, remember I said getting the practice note and heads of argument to the judge on the Monday preceding the Tuesday is actually already too late. The reason is that one only has the weekend to read one's files. So if you are able to, and you are briefed timeously, send the practice note. The earlier the judge gets the practice note, the more useful it is. So if you can do it on the Friday, do so. Even if you say in the note, my heads are coming, my heads of argument will be filed on Monday. In your practice note, you should identify what should be read. Why? When one opens the case lines file, it is often overwhelming. There are so many sections with numerous interlocutories and other related proceedings as part of that file. It is enormously time consuming to work through that lot, just to find what is on the urgent roll for that week. It would be a simple matter to send a practice note in which you identify the section to be read by, stating by way of example, the urgent application appears at section 002, the answering affidavit at 010, the replying affidavit at X, and the draft order has been uploaded at Y. Another option is to use the widely shared note facility available on case lines. Just provide a very brief roadmap for the judge to assist her to navigate through what is often a morass of paper and subsections. The first thing she sees then when she opens the file will be this note with a clear instruction of what is on the roll and where to find it. I should, on this score, share an experience I had last week. I opened a file with 23 sections, one of them with an application for a leave to appeal. The matter clearly had a history. After having spent a considerable amount of time trying to find what was on the Tuesday roll, I posted a widely shared note at 3:56 on the Friday afternoon. It read, kindly direct me to the practice note for the hearing on 22 June 2021. What relief is being sought and what papers should be read? To distinguish it from the orange notes posted by the registrar, I used the color red. My note thus appeared under a 1 centimeter thick red band. It could not have been more visible. Needless to say, I received no response or guidance until the late Monday afternoon when a practice note was filed, which still did not identify the papers to be read. Counsel for the respondent established that the totality of the papers uploaded spanned 2,400 pages. It included 13 applications. This, admittedly, is an extreme example, but explains why you should keep your eye on the case lines file. Be on the lookout for notes posted by the judge and be ready to guide the judge to that which should be read at the earliest opportunity or to deal with other queries. Also, try getting your heads of argument to the judge as soon as possible. Make it as comprehensive as possible. Remember, the purpose of heads of argument is to persuade a court and to assist the court in giving you your order with reasons where appropriate as soon as possible. Now, what I call for are draft orders in Word format. Why do I do that? The reason is this. Before we started holding court on a digital platform, counsel used to hand up 2 hard copies of the order. One used to change the order as you engaged with counsel. That's what I still do, but now only with the soft copy. I call up the draft order here in front of me and change it as counsel and I engage. Sometimes an applicant seeks final relief. I look at the relief and decide what's happening the following day. I would be prepared to stop, thus a final interdict. But what happens after tomorrow, I would only stop by issuing a rule, the terms of which I will have immediate interim effect so that the order embodies both final and interim relief. By way of example, I received an application on Friday to interdict a wedding from going ahead on the weekend and any time after the weekend whilst the individual was still married to the applicant. I must confess, this was a first for me. I've stopped funerals, but not weddings. I granted the final interdict preventing the wedding from going ahead over the weekend, but then issued a rule nisi, calling on the first respondent to show cause why an order should not be made final, that he is interdicted from getting married to anyone whilst he's still married to the applicant and whilst he has not made an application in terms of Section 7.6 of the Recognition of Customary Marriages Act. And a court has not approved a written contract regulating the future matrimonial property system of his marriages. I think it's fair to say that judges are cautious when granting final relief in urgent court, and where, like this matter, there was service but no opposition at the hearing. I find it time-consuming to have practitioner preparing drafts and various drafts being mailed back and forth. I often do a combination. I ask for one redraft of the order to be mailed to me and then refine it in the presence of the counsel. I like to ensure that the order I ultimately grant is the one I afforded counsel an opportunity to comment on. So although it can seem a bit tedious, the process contributes to accuracy and fairness. Also, although the substance of the draft order you send the judge should be a carbon copy of the relief you're seeking in your notice of motion, you must couch the wording of the order as that of an order. By way of example, change the be's to is's. One doesn't say in an order, the respondent be interdicted. One says, the respondent is interdicted. Read and read your order again. It is the most important document in the entire litigation. If it is unclear, it will give rise to problems down the road, and all your efforts will come to naught. Remember, the order you get must be clear to the litigants, and contempt is difficult to show if there is an ambiguity in the order. Also, the sheriff must know what to do. So wear those spectacles when crafting the relief you will be seeking. Take extra care in the formulation of order. Think very, very carefully before you move an application ex parte. Remember that court orders should only be granted behind the litigant's back in exceptional circumstances. In South African Airways, SOC versus BDFM publishers, Judge Sutherland summarized the principle as follows. The principle of audi alteram partem is sacrosanct in the South African legal system. Although, like all other constitutional values, it is not absolute and must be flexible enough to prevent inadvertent harm, the only times that a court shall consider a matter behind the litigant's back are in exceptional circumstances. The phrase exceptional circumstances has regrettably, through overuse and the habits of hyperbole, lost much of its impact. To do that phrase justice, it must mean very rarely, only if a countervailing interest is so compelling that a compromise is sensible, and then a compromise that is parsimonious in the deviation allowed. The law on the procedure is well established. Of course, Section 34 of the Constitution guarantees a right to a fair hearing, which right has been formulated as follows by Justice Yacoub in the unanimous judgment of the De Beer NO versus North Central Local Council. This Section 34 fair hearing right affirms the rule of law, which is a founding value of our Constitution. The right to a fair hearing before a court lies at the heart of the rule of law. A fair hearing before a court as a prerequisite to an order being made against anyone is fundamental to a just and credible legal order. Courts in our country are obliged to ensure that the proceedings before them are always fair. Since procedures that would render the hearing unfair are inconsistent with the Constitution, courts must interpret legislation and rules of court where it is reasonably possible to do so in a way that would render the proceedings fair. It is a crucial aspect of the rule of law that court orders should not be made without affording the other side a reasonable opportunity to state their case. That reasonable opportunity can usually only be given by ensuring that reasonable steps are taken to bring the hearing to the attention of the person affected. If you have to move your application ex parte, and you have substantiated it in your founding affidavit, and you have persuaded a court to grant it, make sure you include in the order the respondent's entitlement to a reconsideration. I normally include something along the following lines. Attention is drawn to the content of Rule 6.8 of the Uniform Rules of Court, which provides that any person against whom an order is granted ex parte may anticipate the return day upon delivery of not less than 24 hours' notice. In that vein, where there was service but no appearance at the time of the granting of the order, I include reference to Rule 612C and couch it along the following lines. The respondent's attention is drawn to the content of Rule 612C of the Uniform Rules of Court, which provides that a person against whom an order was granted in his absence in an urgent application may, by notice, set down the matter for reconsideration of the order. The comments of Judge Sutherland in respect of the steps to be taken to ensure effective service are summarized as follows in paragraph 26 of the South African Airways case that I referred to earlier. He says, in my view, it is incumbent on the attorney who contemplates an urgent application less than 24 hours to undertake the following default actions in effective. Once the respondents are properly identified, the names and contact details, i.e. phone, cell, email, fax, and physical addresses of persons who have the authority to address the application must be ascertained. Obviously, if the issue has already been the subject of debate between the parties and an attorney has already been retained by a respondent, such attorney's contact details will top the list. 2. At the earliest moment after deciding to bring an urgent application, contact must be made to demand compliance with the relief to be sought and to alert one or more of such persons of the intention to bring an application, stating where it is likely to be heard, when it is likely to be served, and the identity of the judge on urgent duty. Agreement should be reached about who should receive service on behalf of the respondent by email or fax or other method. 3. Next, the urgent judge shall be alerted and a report made whether or not the respondents have been alerted. 4. When the papers are ready for service, direct contact shall again be made with the persons dealing with the matter on behalf of the respondent. Where delays occur, respondents must be kept informed by interim calls to report progress. 5. Sufficient time must be allowed for the respondents to read and digest the papers. It is appropriate to send the notice of motion in advance of the founding papers to give the respondents a chance to formulate a view about the relief being sought. 6. When the papers are about to be served electronically or otherwise, the urgent judge should be consulted about when and where the hearing will occur, if at all, and how much notice must be given in the context of early alerts to the respondents. 7. Once served in any manner other than by personal physical delivery, the attorney must immediately call the respondent's representatives directly to confirm actual receipt of all the papers. Something happened in urgent court last week, which is worth mentioning under this topic. The applicant sought a stay of execution of a winding up order pending the determination of a rescission application. The notice of motion distinguished between Part A relief being the stay and Part B being the rescission. The creditor had wound up the close corporation, having served the application at the close corporation's registered address. Of course, this was sufficient service for the order to be granted. But the close corporation had attorneys who had been corresponding with the creditor's attorneys about the very debt in issue. The winding up application had not been served on such attorneys, being the very same attorneys who had placed themselves on record as the attorneys for 3 sureties, which the creditor sought to hold liable in terms of the summons. Now, the existence of a bona fide disputed debt is, of course, tacitly conveyed by the use of action proceedings. I concluded the judgment with the following. The object of Rule 45, capital A, is to obviate real injustice. In my view, and given the circumstances of this case, the creditor ought to have notified ex-attorneys of the winding up application. There were 2 parallel court processes running where the sureties were defending the claim, had filed a plea, and the principal debtor was being liquidated without notice to the attorneys representing the sureties, the very same attorneys who had responded to the letter of demand and who had stated expressly that any winding up application will be opposed. even if not a legal requirement. In my view, the failure to have sent the winding up application by email to ex-attorneys and to have sought the relief without notice to them is legal practice which, in my view, is sailing very close to the wind on an ethical front. Needless to say, I granted the stay, but the point is this: be sure to give notice to those you have corresponded with on the matter. Certain matters are automatically urgent, such as refugee matters, but even there, the applicant should afford the state a proper opportunity to file answering affidavits if they so wish. In this regard, the comments of Judge Weppener are pertinent in that in Ray's several matters judgment at paragraph 16. There are also matters brought against departments of state. Experience has taught that such respondents need time to look into the allegations contained in the affidavits in order to be able to file answering affidavits if they so wish. When these affidavits are filed, the matters can be seen in a proper perspective. Attempts to disallow them to file affidavits are usually based on the judgment in Ars versus Minister of Home Affairs and others, where it was said at paragraph 10 that a detained person should not be deprived of his or her right to freedom for 1 second longer than necessary. Malam J.A., however, added the words that the detention should not be longer than necessary by an official who cannot justify his detention. This statement must be seen in its proper context. It does not say that all persons who are incarcerated are entitled to be released post haste. It deals with unlawful incarceration, and that determination can only be made upon a proper consideration of all the facts as the governing legislation specifically provides for incarceration. By allowing the respondents to place facts before the court to attempt to justify the actions of its employees, the matter can be properly considered. The success or otherwise of the respondent's opposition to the matter can only then be determined. Now, what if you think the matter is semi-urgent? In our division, you should approach the Deputy Judge President and ask for a special allocation. In terms of paragraph 26 of chapter 9.23 of Johannesburg's Practice Manual, the judge to whom an urgent matter is allocated can, if she is of the view that the matter is not sufficiently urgent, that it should be heard that week, but it is sufficiently urgent that it should not be heard in the ordinary opposed motion court, immediately inform the parties of this view, and the parties shall then be entitled to immediately approach the Deputy Judge President for an expedited date to be allocated for the matter to be heard in the special motion court or such other motion court as the Deputy Judge President may deem meet. Also remember that in Johannesburg, urgent applications in terms of Section 18 of the Superior Courts Act for leave to execute a judgment pending an appeal should be referred to the judge who heard the main application. Such judge should endeavour to hear such application as a matter of urgency. The same judge should hear the Section 18 application as regard should be had to the merits and the prospects of success when considering whether an order should be enforced pending the appeal. Approach the registrar of the judge who granted the order. I normally hear the application for leave to appeal and the Section 18 application at the same time. When in urgent court last year, October, I heard an application where a media defendant was afforded 2 court days within which to prepare its answering affidavit. I was confronted with a tricky and novel legal argument which dealt with the interplay between the urgent court's competence to order a media defendant to publish an apology and the speedy remedies afforded by the Press Council, which in that case had been commenced by the applicant but then abandoned. The argument was not dealt with in the heads of argument filed by either party, but for the first time in the oral argument before me. I do not blame counsel for the respondent, as everything happened with such hugely truncated time periods, and he presented a very able and compelling argument despite these challenges. But I use it to make the point made by Judge Kachalia, as he then was, in Digital Printers versus Riso Africa Pty Limited. The urgent court is not geared to dealing with a matter which is not only voluminous, but clearly includes complexity and even some novel points of law. So obviously I'm not saying that an applicant who wishes to develop the law should stay away from urgent court. But what I am saying is that these types of considerations should be factored in when deciding how much time a respondent should be afforded to file an answering affidavit, or perhaps whether the Deputy Judge President should be approached with a request for a special allocation when it is clear that the case is not the ordinary run-of-the-mill matter. I want to conclude with this. The doors of our courts will not be closed to meritorious matters. But your first priority as counsel moving an urgent matter must be to assist the judge to produce the order that your client seeks in a manner that takes account of the judge's workload and fairness to the opponent. Thank you.
Thank you so much, Judge Opperman. There's a question from Advocate Bart Ford.
Judge, thank you so much. The question I have relates to the issue that Judge pertaining to anticipating the return date within 24 hours. Now, I had a disagreement with one of the judges in Pretoria, who shall remain nameless, as to what is actually meant by anticipating the return date. Does anticipate the return date within 48 hours mean within 48 hours of the
24 hours, not 48 hours.
Or 24 hours,
Yeah,
24
yes.
hours, is that within the time period that the judgment was granted, or in relation to giving notice to the other party of the set down of the matter?
Yes. I think there is there is a judgment about this feature, and in that judgment, the judge said that you're still bound by giving notice and setting the matter down on a Thursday for the Tuesday. I'm not entirely convinced that that is correct, because the point is you can't take an order behind somebody's back and then urgently, ex parte, and then expect that very same litigant to stand in queue and either go to the ordinary role or then, give notice and apply Luna Meebles. So for me, 24-hour notice is you find out about this. This is the relief that was granted against you. You give the other side notice of this matter and you enroll it. But your debate. I'm sure. I don't know what was the position advanced in Pretoria, Bart. Bart, you've left me.
The issue in Pretoria was that, like you correctly pointed out, you cannot approach the court urgently and place us under extremely truncated periods within which to respond to. And when we want to exercise that within 24 hours, then complain of us having given the other side too short notice.
Absolutely. No, that's just, that it makes no sense. You just, so as far as I'm concerned, the way to interpret the rule is exactly the way it reads. You take the order behind somebody's back, then you suffer the consequences. That person is asserting a right for reconsideration, which regrettably then everybody has to burn the midnight oil. But you know, so that's my view on the point and my interpretation of the rule. I know there is other interpretations in our division.
Thank you, Judge. There's a question from Doris. Doris, you can simply unmute your mic.
Thank you, Bart. Judge Opperman, thank you so much for that extremely helpful talk that you gave. I would like to know if you'd be willing to publish a list of the case authorities that you referred to during your talk.
Most certainly. I'll prepare a list and I'll make it available to Bart. He told me that this talk has been recorded and that it will be uploaded onto the website, so perhaps he can add this list. Some of these, you know, you will find on Safely, and regrettably, they're not that readily accessible. So I would most certainly make that available.
Thank you, Judge. Much appreciated.
Indeed, Judge. So once we upload it, you can just make that available, and we'll upload it within the link. Judge, there's a question from Laura. Laura, you can simply unmute your mic.
Good day, Judge.
Show your face.
I'm unable to show my face right now, but can I just ask a question? You've dealt with urgency pending an appeal. So with the Constitutional Court being in the spotlight, I just wanted to find out if there's some sort of disparity when you approach urgency in the Constitutional Court as opposed to Rule 6.
It does seem that it's applied a bit differently, but regrettably, I have no experience in the Constitutional Court. But urgency is urgency. I mean, the principles are applicable in all the courts of the land, and it should, you know, be applied in all the courts the same. So, if anything, I think the highest court should perhaps, you know, has a freer hand, and that the interests of justice will play a bigger consideration there. But I don't have personal experience about urgent court matters in the Constitutional Court. You have obviously applied yourself to it. What are your views?
My views would be that they're similar, but having done pupillage, the previous dispensation where we did not do constitutional law as the course outline, you know, I don't have much to say on that, but I would figure they're very similar to those of Rule 6.
Yes.
Thank you, Judge, for that.
Thank you, Judge. There's a question from Islam Musaji. Islam, you'll just unmute your mic.
Thanks. Just on the question of the urgent applications in the Concord, my understanding is that you don't simply set it down on a date in the Concord, but rather you have to seek a date from the court, and the judge president then allocates a date if they believe that the matter is sufficiently urgent.
There we go. There's your answer. I don't know about the practicalities in that court at all. I thought you were asking me about the principles, you know, when considering, Laura, when considering the, you know, urgency. But in relation to how it actually pans out and the practicalities there, I'm completely at a loss. But it seems like Aslam is able to guide you.
Thank you for that.
Thank you, Judge. If there's any further questions, can the attendees kindly unmute their mic and ask Judge her question? Judge, while we're waiting for that, Advocate Bart Ford wants to make a comment. Bart?
It certainly picks up something that Laura mentioned, Judge. PABASA has a very interesting discussion scheduled for tomorrow afternoon at about 3 p.m., where they will be looking at where there's this interconnection between law, politics, and also obviously what is happening presently within the judiciary. And I think it would be a very worthwhile segment to log on to and to consider. For those who are interested in doing so, to contact Raja Budlander at PABASA, and she would make the link available.
There we go. There we go. That's most useful.
Thank you. Islam, I see your hand is still raised. Do you have another question?
I just want to raise something else. Previously, there was a provision in the practice directives that if the papers in the urgent application were going to be more than 500 pages, then it was incumbent on you to make special arrangements with the Deputy Judge President to get a judge allocated to hear that particular matter, and the matter is not set down in the ordinary urgent court. That provision doesn't seem to be in the latest set of directives. And does that mean that you now have to set down those applications that exceed 500 pages in the ordinary urgent courts? Or are you meant to still follow the practice that seems to have developed over the years of trying to get a special allocation?
Yes. Look, I think that was only ever codified, for lack of a better description, in the Pretoria practice manual. But I mean, there has been our drive to have one practice manual that governs the procedure in both divisions, and these, these directives which have dealt with the current pandemic situation, we find has also tried to streamline the process. But I think, I mean, there is a practice that, and what Judge Kachalia said, this is not a court that has the capacity to deal with voluminous papers. So as soon as you see that as counsel, you should really approach the Deputy Judge President, because it's just not, you're not going to get a proper hearing. A judge simply doesn't have the capacity to deal with a large, time-consuming matter. There are too many matters, so you're going to do your client a disservice by keeping it on the roll. Just do the practical thing, the sensible thing, and enroll it. Seek a special allocation. That would be my advice.
Thank you, Judge.
Thank you, Judge. It gives me great pleasure to tell you that there's a question from Judge President Mlambo. Judge President Mlambo.
Thank you very much. I just wanted to respond to this question about the page limit in the urgent court. Judge Opperman is correct. That do the sensible thing. It may not be spelled out expressly as far as Joburg is concerned, but our assumption as the leadership of the division is that practitioners know that if you are bringing a voluminous application, don't bring it in the urgent court. Rather, seek a special allocation with the Deputy Judge President. And a secret that remains is that we always have a spare judge to deal with what we call these urgent applications that crop up out of the woodwork that can't be dealt with in the normal urgent court. So you are lucky if you've brought a voluminous matter in the urgent court and the judges there dealt with it. But do the sensible thing, as Judge Opperman says. If it's beyond the 500-page limit and you require proper justice to be dealt with the matter, contact the Office of the Deputy Judge President and alternative arrangements will be made for your matter to be heard. I just wanted to respond to that. Thank you for giving me the platform.
It's always a pleasure. It's always a pleasure. Are there any further questions? Kindly just unmute your mic.
Hi, Ahmed. I just also want to add to The question asked about the procedure in the Constitutional Court is that like the High Court and any other court, well, not so much the Magistrate Court, but the Constitutional Court also has practice directives. So those can be found online. And if you are unsure of the procedure, that is what you follow. I've seen matters in the Con Court, for instance, where there was no index, where it's clearly stated in the directives that you have to have an index. There has to be a bibliography, etc., etc. So it's important to read the practice directives of every court you go to ensure that you're following the rules and regulations. And good afternoon, Judge Malamba, as well. And then just in terms of urgent matters, I'm not sure, Judge, if you dealt with that in the information dense talk, but I had a matter once where a colleague took an order, even though we agreed to stand the matter down to the Monday, as I was already involved in another urgent matter. And this person then proceeded to take the order in my absence. And there is actually section 612C, if I recall correctly, that you can approach the court with to set such an order aside that was taken in your absence.
Yes. No, I did mention that in my dense presentation. Any further questions?
Are there any further questions? Thanks, Judge. Judge, before I let you go, last week we had acting judge. Sorry, before I get to that, there's a question from Luke. Luke, you can simply unmute your mic. All right, so Luke's, there's a question from Michelle. Michelle, you can simply unmute your mic.
Good afternoon, Judge.
Good afternoon. I am very familiar with you, Ms. Rodriguez.
Yes, Judge. Judge, sorry, my question pertains to the Thursday for Tuesday section of the practice directive. I've had a lot of matters where we get the application served on the respondent on the Thursday and not necessarily all the papers in on a Thursday. So I just want to understand that the whole application has to be ready to be heard by the Thursday so that it can be enrolled and sent to the judges on the Friday. Is that correct?
Look, it's an urgent application and you must make the call as to who must file when, and whether you're going to have your matter ripe for hearing. But of course, you are going to be, sometimes you're going to get the returns of service back from the sheriff after the cutoff date. All of that, and in my special customized directive, I have a provision for that. Make representations to my secretary and explain why the particular document needs to be uploaded. The reason why you can't have the files unfrozen forever and a day is that at some point you've got to read it, you've got to know this is now the finite package that I've got to get to grips with. If I the file, there's an email that comes in and alerts me and say, okay, here's a return of service, then I allow it in and I keep track of what's happening in the matter. Otherwise, it's by way of example, you would have been sitting in your chambers reading and everybody just walking in and out the door, opening their files, plonking things in. You just simply have no control over it. So no, to answer your question squarely, not everything has to be complete. It depends on the urgency of the matter. Ideally, you want an urgent application, everything packaged, nicely sealed and ready at 12 o'clock on a Thursday. But that's not going to happen because it's an urgent application. But so you've got to just be able to justify to then communicate with the judge, to get the file unfrozen and to get it uploaded. But, you know, it's also every judge is the master of his own court. An urgent court, you know, one's got to manage it. Otherwise, it just becomes impossible with all the documents flying in. And that's why I want the files frozen, so that I just can keep control and keep record of what's coming in and out. Does that answer your question?
Yes, thank you, Judge. Thank you.
Thanks, Judge. There's a question from Hasina Kassim. Hasina?
Thank you, Judge. Thank you very much for a very informative talk. I actually just want, without you having to give us a total peek of what happens behind the scenes, just some clarity. I'm fully aware of the, you know, freezing of the roll on the Thursday for the Tuesday, but I was actually quite surprised. One of my matters, which I didn't expect to appear on the roll, appeared on the roll, but the roll was only circulated on the Monday, and I was very concerned that the judge might have spent the whole weekend reading papers that, in fact, parties had already agreed to a postponement. So if it's frozen on the Thursday, is it not possible that the roll can actually be circulated on the Friday at least, to avoid a judge having to read papers over the weekend for a matter that in fact ought not to have been on that roll? Thank you.
I mean, absolutely. Look, ordinarily the senior judge sends out a composite roll on the Friday to the professions, and then you'll know, you know, what it is, but whether your matter's on the roll, etc. The best thing to do under those circumstances, and you will curry favor with all the judges, is if you just use that widely shared note facility and just say, I'm unsure whether this matter was enrolled, it was scheduled to be enrolled, it has become, or it falls to be removed, or it's become settled. Please do not read this file. Then, I mean, it's chicken soup. There's no harm done by you posting that. If it is on the roll, then you've dealt with it. If it isn't, so that would be enormously useful if the composite roll is not published, as should happen.
Thank you, Judge.
Did that provide guidance?
Yes, thank you, Judge. It did. It would be preferable if we could also see it on the Friday, preferably, just to avoid any embarrassment for the parties and the judge unnecessary work. Thank you.
When did you? Was this last week?
Yes. Yes. In fact, Judge, we would have been before you if it had proceeded. And so we only discovered it on the Monday. When the roll was circulated.
We published on the Friday, but apparently the Johannesburg Society of Advocates just published my name. You'll go on it and didn't attach the attachment. But the legal, my secretary established that the Law Society and the Pretoria Bar did publish the entire roll. Well, my role, because I was the junior judge last week. So just check all the websites. I have also asked my secretary to widen the net with that publication and to send it to PABASA and to yourselves, this South African Bar Association website, and hopefully we can publish it, you know, as widely as possible so everybody can see as soon as possible that the role, you know, where your matters to be heard.
Thank you, Judge. That'll be hugely helpful. Thank you.
Thank you, Judge. There's a question from Advocate Mudau. Advocate Mudau.
Judge, I'm using somebody's device, so I won't be able to display my.
I see there you've changed to Mr. Aslam Musaji.
No, Judge, I had an experience where I had a matter which was prepared for this Tuesday. However, due to the fact that there were no exchange, the pleadings were not completed, the matter was not allocated. Then what we then did is that we removed the matter, re-enrolled it to the following week. I understand that the opponent only filed the notice of intention to oppose the day prior and then filed on the very same date where we needed to be heard. So the following week, the matter was then placed on the roll. Now, the challenge that I've been having is that when we were now given papers, the answering affidavit, we had an issue with their papers and we needed to reply, but we were obviously late because the court had already allocated the matter. So I just want to understand the challenge in that aspect. Does it go as per the judge, wherein he or she will allow further exchange of papers, or the matter can then be dealt with as and when the judge instructs? Because that's where the challenge we had. I had to send it to the registrar asking for an indulgence so that we can file our replying affidavit, though it was considered. But the challenge that I had is that how do we go about maybe seeking an indulgence? Do we bring an application for that on the same day?
Look, once again, this is dependent on the judge. You should, when you provide times for filing in your notice of motion, make provision for when you're going to file your replying affidavit. And that should be before the Thursday. So your papers should in principle be complete. But it's also dependent on how urgent the matter is. Sometimes, you must be heard on the Tuesday, and therefore you permit time for filing on the Friday, and then you do your replying affidavit on the Monday. And once again, you then say to this judge, well, here's now the complete set of papers, the urgency warrants it, and you appreciate that it's an inconvenience to the judge because now he or she has to read the replying affidavit, but this is why it's so urgent and this is why it should happen. So it's not as though you've got to bring a formal application because it's, there are 3 sets of affidavits. It's just, you should have filed them by the Thursday, and you should have permitted time for yourself. The reason why you didn't is no fault of your own. It's the respondents that took more time. Now the respondents are before court. They didn't comply. So either the court disallows the answering affidavits or the whole package goes in with the replying affidavit. But that's something you've got to just argue and negotiate with a particular judge. And it's fact specific. It's very difficult to give a general principle that has all scenarios or all situations falling into that category.
Understood, Judge.
Thank you, Judge. The last question is, I think, a follow-up question by Islam Musaji. Islam? Okay, I think he's gone. Back to you, Maud,
Sorry, Ahmed. I was talking while I was muted. Can you hear me now?
I can.
Okay. Just in regard to Hasina's question, just a practical tip. Often by the Friday, you'll be able to pick up on case lines which judge has been invited to the matter and also which judge's secretary or registrar has been invited to the matter.
Oh, there we go. You see?
And so that might be a good indication of if you need to communicate that a matter is going to be postponed or has settled. That's an easy way to communicate then. The second thing on the question that was just the last question, I often, if I end up not being able to file my replying affidavit by the Thursday, which is often because the other side hasn't complied with the time periods I have stipulated, just include an explanation for why that's the case and ask for condonation to the extent that it's necessary.
There we go.
Thank you so much. Over to you, Advocate Maud, for your conclusion.
Thanks, Ahmed. Thank you very much, Judge Opperman, sharing your knowledge and experience with us. And we look forward to having you on a bench for many more years and to see where you go in the future. And yes, and thank you for making time for the Bar Association today. and for answering everybody's questions. I'm sure there will be plenty more going onto the website, as Bart has indicated, or Ahmed has indicated. To you, it will be going up on YouTube. So those of you that are on here will be able to view it again and again going into the future. Thank you very much.
Thank you. It was a privilege and a pleasure. Thank you.
Thank you, Judge.
Thank you.